रेडियो जिंदगी 1170 AM पे वेलकम लिसनर्स, मैं हूं आपके साथ हीरा। शो लेके आए हैं द शाह पीराली लॉ शो, ब्रॉट टू यू बाय द शाह पीराली लॉ ग्रुप। यस, वंस अगेन वी आर जॉइन्ड बाय अटॉर्नी शाह पीराली ऑन एयर विद अस. Attorney Shah Peerally is the founder, president and managing attorney of the Shah Peerally Law Group, which is headquartered right here in Newark. He is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action and social services, and he has a strong interest in and knowledge of the political legal system in the US. He formed his law group to work on the causes that he feels most ardent about. His law group focuses on immigration law with an emphasis on employment-based immigration, and he helps his clients all over the U.S. There are offices in Newark, San Francisco, and Washington, D.C. So listeners, wherever you are, get in touch with them. You can call them up on 510-742-5887 and log on to the website peerallylaw.com. Good morning, Attorney Shah. How are you doing?
I'm doing well, Ira. Thank you so much for the nice welcome. And to all the listeners, welcome to the Shah Peerally Law Show. We really appreciate to have you and also to have you participate with us on the radio show. And of course, before I start, anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So today we're going to talk about a few different things, and hopefully we'll have Attorney Sharif joining us in like 10 minutes or so. Hopefully he's available. Then we will be talking about the situation of EB1 and EB2, etc.
Right.
Because a lot of people have been just holding back on filing their cases. Just like Sharif was saying, is that you can't wait on something that might never happen. When you get a chance to do what is right, take the chance on that, because we don't really work in a way like this. And today we're not going to take many callers today, Ira. We'll just go ahead and basically kind of focus on talking about those.
We do have one caller who's been holding on to the line for some time,
let me talk to the caller right now.
Yes, let's do that.
Because once we get Sharif, we might not be able to do that. Go ahead.
Absolutely. Hello, you're on air with Attorney Shah Peerally.
Yeah, sure. Hi, this is Rajesh.
Hi.
Thanks for taking my call.
Hi.
I have a quick question on my H-1B visa. So I have a stamped H-1B visa till September 2022, and I got my I-140 approved. And currently I'm in India since October 2020, and I'm working remote from India to US employer. I have a full-time employment. I just finished 5 months in India. I'm just worried, is there any rule for H-1B employee can stay in India like only for 6 months and they should come back to US? Is there any rule?
No, there's no rule as such. However, if you stay too long and the H-1B itself expires or the company cancels it, then you won't be able to use the same H-1B to come back. But no, there's no limitation per se how long you can stay. But ultimately, if let's say you stay like 2-3 years and then you try to come back, you won't be able to come back because it will already be expired. And if it is not expired, they will ask you the questions why you stayed outside long. But if it is you're working for the same company and there's no issue, etc., you should not have any problem with that.
Okay, so are they in the port of entry? Am I going to face any immigration questions like why I stayed so long in outside USA or something like that?
No, they can ask, but you can explain that whatever reason you have, just tell them the truth. You should not have any problem. Like I said, the only thing that will cut it off if the company themselves cancel the H-1B, or ultimately if you already passed the date on the I-797. But usually, no, it's not a problem because a lot of people travel and work from abroad. So one of the things you need to do when you're traveling back, make sure you have a letter of employment with you, and make sure you're ready that they put you in secondary inspection just to question you about the situation. But usually there's no problem.
Okay, got it.
Okay?
Yeah, thanks.
Okay.
Thank you. Thank you very much for calling in. Listeners, let me remind you, today we might not be taking a lot of calls, but if it's super urgent, if you really need to ask something, you can call us right now on the studio number 510-657-1170. Otherwise, definitely you can call Attorney Shah Peerally's office even now as we speak and make an appointment. 510-742-5887 or log on to the website peerallylaw.com. Yes, Attorney Shah. So you said we're going to be talking about EB1s and 2s?
Yes, we're going to talk about that once we get Sharif aboard, but I wanted to mention a few things on H1B. The lottery results have already started coming. We should get all of them probably by the end of today, I think. It might go a few more days, even though they say today is the last day, but bottom line, it will be today. But there's something that happened in H1B. As you know, I don't know if you're aware, but a lot of cases were denied before H1Bs based on those previous memos, like the Neufeld memo, the employer-employee relationship, the contractual relationship, etc., etc. What the USCIS are saying now is that because those memos have been rescinded by the court, now what they're going to do, they're going to allow people to file motion to reopen. The question, I don't have the details. Usually a motion to reopen can be filed only 30 days after. So now the question will be, older cases will be able to be reopened. So that's something that we'll have to look at. But the truth is now, if you get a denial based on that, you are eligible, well, not eligible, but you should file a motion to reopen. A motion to reopen is like an appeal, but we just use motion to reopen for H1B, where they will reopen the case and probably approve it. So that's some good news that we are getting from USCIS. Of course, we are getting a lot of good news coming one by one, but that's one thing which is not really Trump's fault. So I don't want to put that on him, but during his time, the memo was rescinded by a court during the time of Trump himself, and now they're just applying it. Now, the other thing that that we are seeing is that the USCIS is accepting the final dates on the visa bulletin. As you know, there are 2 dates on the visa bulletin, and USCIS was supposed to take the what we call the filing date. But then you're seeing a lot of situation where they're not refusing. They're saying, no, you have to go by the final action date. So that's another thing that people are fighting against, and hopefully this will not be applied, because the entire purpose of it was, by the way, under Obama that this was introduced, where you have 2 dates on the visa bulletin. So this needs to be worked out also. And just to let you know, I know I have listeners all over the world. I say special hi to all my friends around the world. I know people are texting me right now, listening in India and Middle East also, and then some people even in Mauritius, my country of birth. So I wanted to say special hi to all of them. And then I'm going to check. The thing is, we are going to a situation now that we have all those problems that were there under the Trump administration that are getting fixed ultimately by Biden. But bottom line is that we're not going to see everything be fixed, and that's why we were telling people, don't count too much on all those stuff that you keep hearing on the news, like, okay, suddenly everybody's going to get a green card. They're going to make all the dates current. It is possible you will see jump on the visa bulletin, but it's not going to get current the way people are thinking. EB1 did get current, by the way, and that's why we're encouraging people to take advantage of it if you qualify for it. So a lot of things are based on rumors, and sometimes rumors do come true, but the truth is that it's not like that all the time, and you need to go with what you have in hand right now, and you can adjust at a later stage. And that's what me and Sharif have been discussing previously when just Biden won the elections. Everybody was kind of jumping, Biden is going to clear everybody's case. It was not going to happen because it's very, very difficult. It creates a lot of problems, and not only in the system, but it is going to be an influx of people coming in, which is not really kind of 100% welcome, because the system of immigration is there to control at least the border. So some people will get it, some people will not get it. So that's why we're telling people, just be patient. Hopefully good stuff will be coming, but that means you should go for the for the good stuff. I don't know if Sharif is already there, but let me know if you can get hold of him. But I will. Until then, you can still call the studio lines, and you can give the number, please, for me.
Listeners, you can call us right now on 510-657-1170. That's 510-657-1170. That's the studio number. If you have any immigration-related question, employment-based or not, you can call us and ask Attorney Shah your question. 510-657-1170. I am trying to get Attorney Sharif on air. I'll let you know, Attorney Shah, when he joins us. In fact, you'll just know yourself. You always do.
Exactly. Thank you so much. I really appreciate it for really helping and making the show successful. And just to let people know, we were talking a little bit about the H-1B situation. As you know, in the past, a lot of people got RFEs and denials based on the employer-employee relationship, which is actually was a nightmare at one point. Not only the employer-employee relationship, all those issues of having end-client letter, etc., etc. Now you can do without it, but that doesn't mean they cannot ask you a question about proving if you really have a job offer. So distinguish that. It's not like they used to ask you something very, very specific, the name of the employee, the job description, etc., etc. And many and clients that we call them, the final clients that were taking the people, they were not really kind of ready to give that, because it was really kind of almost an invasion of their own privacy, and they didn't want to touch those kind of situation, and ultimately they were refusing to take candidates. But now, with this new rule, hopefully this issue will be solved. Having said that, that doesn't mean you should not prove that you actually have some kind of work for that person, because if you just say, hey, I have work, but you cannot prove it, it will come back and hurt you. So I highly recommend that you make sure you talk to an attorney before you make any move, and you can call our office 510-742-5887, 510-742-5887. Just to let you know, we are still within kind of a shelter situation, so most of our staff are working from home. So if in case you call, just leave a message. Hopefully, if nobody's picking up, we will call you back as soon as we can. So just bear with us a little bit. And if you need help on anything else, please feel free to reach out to us somehow through email, info@peerallylaw.com. Just check on our website. You can get that. Now, talking about the situations right now, we are seeing a lot of good news, by the way. So we have to admit we are seeing approvals, we are seeing receipts coming out, we are seeing a lot of good things happening. But having said that, we are also seeing a different kind of approach by the government, which was very much the approach of Obama. And now it's under Biden, who has kind of taken over. He's very much encouraging immigration, by the way, but they are encouraging some kind of immigration which is quote-unquote healthy immigration, as we call it. And that's going to also change the way immigration look at stuff, right? So, for example, it used to be under Trump that many cases they were not encouraging to file, like asylum cases, like even employment-based. Pretty much everything immigration was having some kind of obstacle previously. Now, many of those obstacles are being taken away, so you should apply for your case. Now, having said that, again, just because they are allowing you to file doesn't mean you're going to get an automatic approval. So that means you need to make sure that you basically hire the right lawyer to do the work. Or some cases you don't need a lawyer, by the way. So don't just jump because a lawyer will do that. It will work. And also the good news is that we have this famous 944 form, which was a nightmare for many people, that has been removed, and that's something which has been done since I think mid-March, around March 19th or March 20th, they decided to remove that. And that's a great news, because a lot of people were getting worried. Why would they have to ask so many questions? And how do I deal with a situation where if I had used some kind of emergency, do I get penalized, etc., etc.? And this is gone now, because On March 19 to 2021, the USCIS removed that, and also they are extending for people who are from Australia. By the way,
Okay.
there's something called E3 visa. I don't know if I have any Australians. I think I have few Australians listening. The E3 visa is very much like an H1B, although it's not a dual intent visa kind of. The E3 visa are for people who are Australian citizens. You don't have to be born in Australia, and it's open all over the year. So it allows you to get into the United States by filing an E3, and now they have extended it for premium processing also, which was not there. So that's another thing that people should consider when they're trying to come to the U.S. And ultimately, if they are not able to get that, then they can also rely on H-1B. The same thing applies for Canada and Mexico. There's something called TN visa. The TN visa is a NAFTA product which allows people who are from Canada or Mexico to come to the United States as long as the job is under what we call the appendix of NAFTA appendix. You will see that. You can Google. I think I have it on the website also. The NAFTA appendix kind of gives you the kind of jobs that will qualify for the TN visa. The TN visa is very interesting because it doesn't really have limitations. You can be on that for, well, actually it's an increment of 3 years and 2 years and 2 years, but you can keep basically extending it forever. I know people who will stay on it for 10 years, 15 years, and they're not interested in a green card because they're Canadian citizens. All they want is to work in the U.S., and that's it. And the TN visa is a very good option. So all those visas, we tend to ignore them because everybody goes for H-1B, L-1B, and they tend to ignore other kind of visas like O-1 visas, which we have talked about extensively when Sharif was with us last time. And again, hopefully if he's here today, we will talk about that. But since he's not here, just go ahead and give the number. I can still take few callers if they're interested to ask any question. I'll be glad to answer.
Absolutely. Listeners, remember you can call us right now. If Attorney Sharif, I've been trying to reach him, he's probably not joining us today. So we will be able to take calls. If you have any questions, call right now on 510-657-1170. That's 510-657-1170. That's the studio number. You can call and ask your immigration related questions. Otherwise, if you'd like to have a one-on-one discussion with Attorney Shah or his team, call the number 510-742-5887. That's 510-742-5887. And the website is peerallylaw.com. That's the website where you can get all this information about what all are the areas that Attorney Shah and his team can help you. Remember, East Coast or West Coast, they can definitely help because the offices are in Newark, San Francisco, and Washington, D.C. Let's continue, Attorney Shah.
Thank you so much, Ara. So just to let people know, we were talking about different things, especially we talk about the H-1B. Now the lottery selection is probably almost over. Hopefully we are going to see people in. So if you got in now, they will let us know when you can file for your H-1B. So be ready for that. One question that a lot of people ask me, and I'm getting that very frequently, I don't know why, because a lot of people, have been laid off, especially in H-1B, and they have, as you know, this 60 days grace period, and now suddenly they find themselves with no jobs. But then when they apply, they get offers on 2-3 companies, right? So what do? Can they apply 2-3 companies at the same time within that grace period? The answer is yes. In fact, it's a good idea. But now the question is, what do you have to do if you file it within the 60 days? So let's say you apply with company B, C, D, 3 companies, and they all got pending, and one even got an approval, for example, within the time. So do you have to go and work for the company which is approved, or you can start working with the company which is still pending the case? Like let's say, for example, B, the case is pending, but this rule applies only if you're within the 60 days, okay, grace period. So let's say company B, the case is pending for your H-1B transfer. Company C is approved and company D is pending. But you really want to work for company D, but you got an approval for B. So what do? Do you have to join B? The answer is no, because you filed it on time. You can still go with D. And let's say now after that you're working with B and you're working with D, and then in the meantime B get approved, and you want to move to B. You can also do that. So this is a little bit tricky when people try to understand it. They don't understand how come you can have three H-1Bs. H-1B is one of those visas that allows concurrent H-1Bs. There are a few visas which are like that, and usually H-1B is one of them. And I think there's no other visa, in fact, that really gives that, if I'm not mistaken. So this is something that I get very, very frequent, as a very frequent question, because a lot of people get scared, get worried, and they don't know what to do. They panic, and they make the wrong choice, and they end up by regretting it. So call us if you want us to analyze in details what are your good options. Because when I speak to my clients, I've done this for now, for almost now going on 17 years, almost 18, and people, I can feel certain things in terms of how the clients are dealing with the company and what is happening with that company. So there is an analysis from experience and also from a legal point of view that I can kind of give people an idea. By the way, I do most of my consultation, so I can give them an idea what is the best choice for them, because oftentimes the confusion arises because they don't know which one to pick. When they don't have anything, they don't have anything, but when they got it, they got a bunch of them. So, and that's another thing that a lot of people are really confused about, and if you need help basically on assessing that, we'll be more than glad to help you. So that's one thing that many times people just get worried because they just got laid off, and now they're getting all those offers, and at the same time one is approved, and they want to know if they will have to move with that company, or they can just let it go. You can let it go, but one thing I just want to let you know, usually when this happens, oftentimes the company can come back and claim whatever they spend on the H-1B application for you. Only the application amount and legal fees, not really a penalty fee. For example, someone can say, "Hey, I spent $5,000 for you on your case with your lawyer and everything, but I want $15,000 because I lost some so and so contract." This is usually called what we call punitive damages. Kind of, it doesn't really hold. But if they ask a reasonable amount to cover the cost, they can do that. So that's only one drawback that a lot of people need to be aware of, because you don't want to just suddenly apply with like 10 companies and they start claiming money from you. So be careful on that. Now, another question I get from people is, what happens if they come here and they got an I-140 with a company? An I-140 is the employment petition to the USCIS after you do the labor certification, or if you're doing EB-1A, national interest waiver, etc., you use an I-140 petition. And what happens is that, let's say, for example, you got a case approved with company A, and then you quit company A. What happens to that I-140? Well, first of all, if 6 months has passed, there's a law that was passed by Obama before he left, where they cannot cancel that I-140. However, not cancel means you can use that I-140 for your priority date, and you can use that I-140 for H-4EAD for your spouse. You can use that I-140 to extend your H-1B, but to get a green card with it, unless the company accepts you back in the company, you probably will not be able to do that. So what you need to do is to go ahead and file a new labor certification with the next company, and of course an I-140, and you borrow that priority date from the previous company and you bring it here. So that's one thing that a lot of people tend to get confused about. Now, what has happened, and I know a lot of people get confused because they have been reading on forums that you can transfer the I-140. The only time you can transfer an I-140 from company A to company, not only time, the few times, number one, if it belongs to you under a national interest waiver or an EB-1A, that you can move it anywhere because it stays with you. Number two, you can move it, an I-140, if an adjustment of status was filed together with that I-140. which is what we call an AC21 transfer. And an AC21 transfer basically means you are taking, it's under section 1 of, AC21 section 104C, if I'm not mistaken, where you're basically taking the entire case, you're moving from one company to another. And that's called a portability of AC21, and it's under section 104C. And it requires two things. Number one, it requires that 180 days has passed, and has passed since the case was filed. And number two, you move to a same or similar position. Let's take number one, which is the 180 days. The 180 days, a lot of people ask me, when does 180 days run? Technically, if you're filing an I-45, I will count my 180 days from that date. However, let's say you file it joint filing, like I-140 and I-45 was filed together, you can take that date also and you count your 180 days. So just to be on the safe side, that's the way you do that. Now, 180 days has passed, and second thing, it requires that you move to a same or similar position. Going back to the 180 days, I missed something I wanted to mention. A lot of people also get confused on that part. The 180 days is not really, it has to have passed for you to move. It has to be alive for those 180 days by the time you file what we call the Supplement J, or as it used to be, AC21 letter. So it gets tricky because a lot of people get very confused on that whole thing. Even lawyers do get confused because the whole entire system itself, in practical terms, the law is clear. It's just that in practical terms, it gets a little bit confusing. So to be on the safe side, always wait the 180 days, although there's no requirement to wait for that. All it says is that by the 180 days, the I-140 has not been canceled. And now with the rule, they cannot really cancel the I-140, so you're kind of in a good shape. Let's say, for example, you file an I-140, it got approved.
Attorney Shah, we have a caller over here who's been holding on. Let's take this call.
Yeah, let me take the call.
Hello, you're on air with Attorney Shah Peerally.
Yes, I'm here.
Yes, please go ahead. He's listening.
Yes,
Please go ahead. Attorney Shah is listening. Yes.
Yeah. Good morning, Dr. Lawyer Shah. Thanks for taking my call. This is Ram.
You're welcome.
Yes.
Hi, Ram.
I have a question. I'm a U.S. citizen, and I sponsored my married son in 2013, and the current date is showing 2010. Is there any progress on that, sir?
I didn't check the visa bulletin, but it will be moving soon. So in a couple of years, he should move. But we are expecting some kind of movement this year because Biden is reshuffling everything. So by October this year, you might see a jump. But it won't become current in 2013. So I think your waiting time will be around 1.5 years or 2 years maximum. Okay?
Thank you.
Well, that's my take, okay? I might be wrong. So I'm just saying
I understand. Thank you. Your dad had also given me the more or less same timeline. And is TN visa open, sir? We are Canadian citizens. My son is a Canadian citizen. Is TN visa open now?
TN is always open. So TN
okay. Thank you. Thanks for your kind help.
But just let me know if you need help on that. Call me. I'll be glad to help you.
Okay, thank you. Really appreciate your time and your information. Good work. Thank you.
You're welcome, sir. You're welcome.
Thank you. Thank you very much for calling in. Listeners, if you also have any questions, remember you can call right now on the studio number. You can also call and ask your questions. 510-657-1170. Yes.
Yes, thank you so much. Thank you. So feel free to call because I don't think we'll have Sharif today.
Mm-hmm.
I think he got busy. He's not even texting me back, so he might be stuck with a client or in court. So hopefully... he said he's available. Maybe you can call him right now if it's possible.
Okay.
So in the meantime, I'll just talk a little bit about the I-140, and Sharif will talk a little bit more about I-140 and EB-1 also. So what we are talking right now is about the situation of I-140 moving the case from one place to another. The second element is the same or similar position. What same or similar position means, you just have to match. There's a code that is there. You have to match that. it's not really the code, it's other stuff. So we'll talk about that more in the next show. So since we have Sharif, we're not going to waste too much time. Assalamu alaikum, Sharif, welcome.
See, you always know you always know he's joined us.
Oh, yeah, I have this sixth sense, you know that.
Awesome.
So,
I think there was several callers that were there because I couldn't get through, but, thank goodness I got through, so thank you for that.
Okay, great. So Sharif, tell us a little bit what's going on right now. I think we have another 20 minutes, so tell us what is hot right now on your side.
The biggest thing I think is those clients of ours who were able to be a little bit patient with the changes that were taking place have really benefited. I think we saw just in from February 15th until the first week of March that there were extremely high approval rates, particularly in EB1A category and national interest waiver. Those, that basically we had some cases that we finished in November and December and even January that we recommended to our clients because of the changes in administration that, you're better off not submitting it now at this very, kind of polarized time. And that after what we estimated was February 15th, the environment should be a little bit more stable. And I think we're seeing that to be the case. I mean, it's not as if that, everything is going to be easy now. I wouldn't go that far. But I think that what I've seen is, so for example, I looked at the data. So I looked at the data and I found that, around 80% of those cases were approved without RFE. And the 20% that did get the RFE, it was not completely unreasonable. So, there were probably things that could have been stronger in those profiles. So, it's almost like a normal adjudication for EB1A, which I think for the past maybe or the last 8 to 12 months of the Trump administration, it was not normal anymore. It was almost like, very high level of arbitrary request for evidence and things of that nature. So I think those arbitrary requests, at least with EB1A, those are going to be, history. That's not happening anymore for EB1A, national interest waiver. And then I'm hearing that, better obviously, but I'm hearing that that similar thing will be happening with H-1Bs, starting, I think it is going to be, ending, actually midnight tonight was the expiration of those previous, executive orders. So, we're just kind of shifting into, I wouldn't say a favorable environment, but I think we're shifting into a normal environment. So that compared to where we were is good news.
Exactly, and that's major because at the end of the day, a lot of people are actually kind of worried, and they saw a lot of denial. But that doesn't mean one thing. People now thinking, because I'm getting emails today, I got someone who said, "Oh, how come I'm not getting approved? You were saying it will get better." But this is nothing to do with Biden. It's just there was a backlog. We are in a pandemic, and everything is getting delayed, right? So we don't really have control over the time, but still they're doing better. We're starting to have receipts when they were pretty much almost ignoring people. So this is hopefully going to... But tell me one thing, Sharif. I was wondering, remember we were talking about the strict constrictionist kind of style that the USCIS was adopting during kind of the Trump administration. Are they still taking that approach, or now it's more totality of circumstances? It has shifted again.
I think it's shifting back. So, as you know, they have not yet appointed the new USCIS director. But I can tell you those people out there who are now thinking about, is it appropriate for me to consider EB1A? And they were on the fence last year or the year before. Now is really the time to get in because the environment is much more favorable. So regardless of whether they've implemented that now, it's not very clear because, to be honest with you, most of the approval, as you know, they don't tell us why they approved it. They just approve it. And that's the majority, vast majority of our cases. So where the RFEs are coming, I've noticed that they were a lot more carefully crafted, and they were not as arbitrarily denied as previous. So I do not think that they are applying that strict scrutiny or plain language constraints anymore, but it's not 100% clear. There hasn't been any specific policy memorandums on that, and we really don't know. But what we do know is that, over the next, you could say 4 to 6 months, it's going to even get better. So, if somebody's thinking about applying, it really is, I think the best environment to apply in, probably for, at least the last 5 years. So, that's kind of where we are now.
And I would encourage people to go for the EB1, because look at what EB1 has done right now. We got this current time. People who were expecting to wait like 10, 20 years when they came to America because their friends told them, oh, I waited 10, 15 years, have gotten their green card sometimes in 1 or 2 years. And
exactly.
And a lot of people have not more willing to take the chance. And I get this call all the time, hey, I've been waiting for 15 years. When I ask them, did you try EB1? Well, no, my friend told me I won't qualify. But then how many of those we got, and we got approvals? So
exactly.
Tell us a little bit about that, because
and probably their friend is doing EB1 behind their back that's telling them not to apply. So, I think that, we definitely have seen, like just in this last batch of cases, for example, there's been even people who are working for consulting agencies and are doing projects at different, for example, healthcare has been a huge impactful area where we're getting approval. And also, people who are working on projects in government agencies. I think those two areas in particular have been doing very well. The biggest area of success, I think, has been products. So anybody who's involved in the creation of products, so it could be like security-related products, it could be just information, database, extraction, like for example, a lot of folks have been dealing with, using data to optimize, business practices. That's definitely something that has been used. Now, this is not now. Here's, I think, one area, and I'll just be completely honest, where I think people probably do not have as good of a chance. That is in customer implementation. So, like, if you're doing solely, if the only thing you're doing is customer implementation, then you might not quite, be able to position yourself. But those who are in product creation or, actually optimizing the technology on the software engineering side, that is a much stronger area. Now, I don't want to discourage anyone, at least from investigating, because if you are in customer like what they call integration or, client, relationships or implementation, like there could be avenues where, if it's a certain type of client that it will still work, but, it is one area where it's a little bit more difficult, because when we're thinking about EB1A for kind of IT or software engineers, we're definitely thinking about that you're performing in a critical role for an organization that has a distinguished reputation. So even a client-side individual will be able to possibly show that if they're dealing with, for example, the high-profile clients or, making, very kind of leadership-level decisions with customer relations. But the area where I think you struggle in terms of just client implementation only as opposed to product creation or, for example, actually, let's say optimization, so either creation or optimization versus client implementation is with original contribution of major significance to the field of endeavor. Because when you're looking at an original contribution of major significance to the field of endeavor, you have to pretty much figure out, what is original about your work. So, somebody who's creating product, like let's say they're creating a security product, right? And that security product, is being implemented at a state agency, right? So there's originality in the sense that you are responsible for creating that security product. And then there is significance because there's a contract with a state agency, and then maybe it's, talked about elsewhere. So with like solely implementation, what often happens is the product that they're implementing already exists, right? So let's say you have some kind of like CRM software that you are just doing client implementation for. Well, that might be a very significant implementation, right? It might be for a very large organization. It might be worth, multi-millions of dollars and all that kind of thing. But the difficulty that you're going to have is going to be proving originality, right? Like, how do you prove that you're the original creator of that product if it already existed before you started with the company? So just the fact that you're implementing a product at a client at a client's organization will probably not work. So, I just want to be straight up with people because, we're going to tell you whether you have a shot or not. I mean, we're not in the business of taking cases that are not going to be approved. So, even if you are in client implementation, don't stop yourself. Get a consultation. Let us know that what your situation is, and we'll give you the honest feedback and tell you whether or not we can find a different path for you. Because, there might be hidden gems in there and within your profile. But ultimately, anybody who's in even like database administration, I like to kind of give a euphemism or another name for that. I call it database optimization because, we've done a lot of cases successfully approved where a person has replaced a legacy database with a new database. Now, that will definitely work if you're responsible for creating the new database. So, when you're, and this is true of a lot of people who are consultants. So, whether you're working directly for an organization and doing database migrations, or you're working at a client location doing database migration, you definitely want to look into EB1A. And anybody that's involved in product creation, I would say that's number one field for software engineers in EB1A because, that proof of originality of work is really the basis for many of these cases, demonstrating that you're recognized as being an expert within the field through having, created a specific kind of, product. So that's where we're seeing a huge amount of success, I would say, is with product creators and, database optimization experts. And overall, like security field, I think, definitely is top. And then the other one that is, I would say, nearly at the top would be the product chain. So, for example, supply chain, optimization, making sure, because this now has security implications for the U.S., where, if supply chain security and supply chain optimization are properly dealt with, then that has, a lot of benefits for the national interest. And because it's a relatively young field, you could really show that your work is highly advanced at the very top of that field. So, those are some of the few areas that come to mind when I think about the recent success stories. And, just overall, we're, continuing to be heartened by that success. I wish every single person could get approved. It's, sometimes a little bit subjective process with some of the officers, particularly when you think about where the, where the cases are located. I think, for example, a lot of people say that, so for EB1A premium processing, you're either submitting to Nebraska or Texas. And many people tend to think that Texas is more favorable. I actually don't think that's the case. But what I do think is the case is that the Texas Service Center is more favorable to Texas-based clients because if you're working, for example, in the oil and gas field or like energy in general, or just happen to be working in some kind of IT field as well that is based out of Texas, there is some bias among those officers in favor of Texas-based applicants. To be honest, we have noticed that. So those of you who are in Texas, you could probably, get a little, and this isn't like 100% proven. I don't have full data on that, but I would say that it seems to be the case that more often than not, cases based in Texas and filed in Texas have a favorable result as it relates to EB1A without much pushback.
That's good to have this feedback, Sharif. Just to let people know, this is the Shah Peerally Law Show, and we are in conversation with Attorney Sharif, who handles the office in the Washington, D.C. branch, and he basically focuses on EB1, national interest waivers, EB1 A, B, C, which means basically for L1 also, L1A visas, E2 visas, and Sharif, one thing that I wanted to really kind of go over with you is that national interest waiver part, because now more and more people are seeing the advantage of having a national interest waiver, because they all always say, oh, it's just an EB2 and I'm from India, but the biggest advantage that we have with that is that it stays with you. Look at what's happening right now. Suddenly people got this days current and they already left the company. They don't have another company filing for them. And now they lose their chance when if they had a national interest waiver, they might already kind of have this. Tell us a little bit about the national interest waiver, especially now a lot of people in the medical field due to the pandemic, they are asking me, hey, maybe I qualify for that. Tell us a little bit some samples of the kind of people. They absolutely do.
I think that we've been able to get people in the medical field, outside of the medical field, in IT, and energy, definitely approved for national interest waiver. And that individual who has maybe changed jobs and the new employer has not yet filed a perm for them, and their dates are current, I would encourage him or her to file concurrent national interest waiver with adjustment of status if their date is actually current, and we can turn those around relatively quickly. A national interest waiver is going to probably take a lot less time than an EB1A in terms of preparation of documents and submission, but the processing time that USCIS has definitely takes a lot longer. So if the person is current in terms of their date, then you might want to file adjustment of status at the same time as the national interest waiver. Now, we've seen also national interest waivers are really, really good because not only do you not have to have your employer sponsor you, but you also are able to, change jobs without fear. So that's a big deal for a lot of people. And how many times has it been that somebody finally their date becomes current and then the employer says, oh, I'm not able to file a supplement J, I-485 supplement J for you. Or, they just drag their feet with the application of green card. You're dependent solely on your employer, and they don't have any interest in you getting a green card. So having the national interest waiver is a kind of freedom that provides, ability to, adjust status. And at the same time, you can apply for an immigrant visa if you're outside of the U.S. So let's take a scenario where someone has a, maybe EB2, approved I-140 in a previous job, like in 2013 or 2014, then they decided to go to Canada, or they want to go to Canada or want to go to a different country. They can actually apply for a national interest waiver, preserve their 2012, 2013, or whatever their previous priority date is, and keep that I-140 approval with them. And whenever their date does become current, then they can, apply for immigrant visa based on that I-140 national interest waiver. And the reality is that we are seeing some advancements in EB2, and we probably will see a little bit more. So that national interest waiver is a very, very powerful tool in our arsenal in terms of making sure that people are able to be successful and protect themselves and their families.
Just to remind people, we don't have much time left now, Sharif. I think we have 2 more minutes. Just to remind people right now that a national interest waiver doesn't require an employer, and it doesn't. And it also doesn't require you to be in the job or even be in the country. So we can file a national interest waiver while you're outside. So for all our listeners listening outside, if you want to look into that, we can process the entire case until you get here through the through the Consular processing. A national interest waiver is a straight green card that can take you directly from your country and bring you on a green card. In fact, I've done few cases of national interest waiver for countries especially who have current dates, right? And they come pretty much, they don't even have to go through the hassle of H-1B or anything. They come straight on a green card. So that's a very, very good advantage. And you are not dependent on any employer. You don't need an employer. You don't. Let me ask you a quick question right now, Sharif. I think we have 1 minute. You don't have to be applying a national interest waiver in the field of work that you are working, as long as you qualify for it. Even if you have the qualification but you're working in a different field, you still can qualify for national interest waiver, right?
Yeah, absolutely. I mean, there's actually what they talk about within the national interest waiver statute is what is your proposed endeavor. So, for example, one may be in one particular field working, and I did a similar case like this, where they were working in an IT job, but their real passion was to work in the kind of mechanical engineering, like it was actually wind farms. And, they had that background from Europe previously, but because of the H-1B constraints, they happened to be working an IT job for the time being. So we applied for the national interest waiver, although they were presently working in an IT job based on that individual's past, distance past and future endeavor, that what is your future endeavor? That's what the national interest waiver is all about, is your proposed future endeavor. So that's what it talks about.
Thank you so much, Sharif. Thank you, Ara. I think we're almost done, right, Ara? So
yes, we are.
Anything we told you today is our opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any question. Thank you. Thank you, Sharif. We'll be back next week, right?
Thank you.
Thank you. Thank you, Attorney Shah, and thank you, Attorney Sharif, for joining us today. Listeners, thank you very much for tuning in. Remember, now you can call the office number 510